Hello, good evening, and welcome to Unacademy. Welcome to Stage 1 of Conquer Prelims 2026. I hope by now you're aware of the schedule and the stages. In Stage 1, we will discuss current affairs of the period January 2025 till December 2025. Today is session number 1 of Indian Polity. Tomorrow, session number 2 of Indian Polity. Today, we will discuss all the important current affairs topics related to Indian polity, which appeared in various newspapers between January to June 2025. And tomorrow, we will cover July onwards. This initiative will be on YouTube. And if you are excited about this stage, do let me know in the comment section. Do not forget to press the like button and subscribe to our channel if you haven't yet. And before I proceed further, this is something that you're all aware of. If you want test series, which is affordable and at the same time which comes with money back guarantee, where if you're unable to crack the prelims examination despite attempting all the 30 tests, you can take the money back. And this test series is available for 1999. Let's get started and let's look at topic number 1. And before I forget, the PDF of this session would be provided on our website. The link to reach that website page is provided in my Telegram channel. The link to my Telegram channel is also provided in the comment section. Let's look at topic number 1, no detention policy, a very important topic for the upcoming prelims examination, primarily because of new national education policy, because of the controversy surrounding PM Shri, Samagra Shiksha, and because of the tussle between few states such as Tamil Nadu, West Bengal, and the union government on education. And we will keep it crisp, strictly keeping in mind the prelims examination. You would know that Right to Education Act was enacted by the Indian Parliament in 2009 and it came into force on 1st of April 2010. One of the most important features of this Right to Education Act was no detention policy, which means a student will not be detained. Why? Because it was thought that detention is demoralizing to children. And if we detain students, the drop off rate would also increase. Then, because of the various reports released by various institutions, which we will discuss today, there was an allegation that the quality of the teaching has drastically reduced, and the teachers are not able to ensure the outcome amongst the students, and students are also not preparing well. So, then in 2019, and this is the fact that you have to keep in mind, in 2019, the law was amended, the rules were changed to allow the states that if you want, you can come out of this no detention policy. And immediately after that, 18 states and union territories, they decided to drop this no detention policy and they started detaining kids who have not qualified or cleared the examination. Now, in December 2024, what happened? The union government changed the rules of this Right to Education Act 2009, and thereby now this policy was applicable for the central government schools as well, the Kendriya Vidyalayas as well. Now, listen to me carefully. That does not mean that a student who has failed in this examination would be automatically detained. This is a very important fact that you have to keep in mind. If you fail, 2 months of extra teaching will be given to the students. And after that, there will be a second chance of re examination. And in that re examination, also, if the student fails, then the student will be detained. That's one thing that you have to keep in mind. Not just that, NCRTs, it had a very important policy called continuous and comprehensive evaluation. That means no detention policy in the 2009 Act was not meant to be a standalone policy in which the students will not be evaluated at all and they won't be detained either. It was ensured that teachers would continuously evaluate these students because year end examination will not satisfy and guarantee whether the students have learned accurately or not. We need to continuously and comprehensively evaluate the students on a regular basis. But the problem was that the teachers were not trained in how to fill these forms, which were talking about continuous and comprehensive evaluation. Then there are some reports which I'm talking about. The annual status of education report. Who releases this report? This report is released by a non governmental organization known as Pratham. And there is also another study. Department of School Education carries out a survey known as National Achievement Survey. If there is a match the following type question, ASAR, the annual status of education report, is not released by the government, it's released by a private non governmental organization called Pratham. But then there is National Achievement Survey. It is released by the union government's Department of School Education. But sometimes, if you look at polity, if there are some events, some issues, some topics in the news, it is not that UPSC may only ask about those controversies, but the static portion of that issue can also be asked in the examination. And ideally, it is these static portions which are asked in the examination. And this is where you need to know few important details regarding the Right to Education Act of 2009. This is the law which was meant to implement, give shape to a fundamental right, Article 21, capital A. But this right to primary education was not a fundamental right originally mentioned in the Constitution. It was provided through a constitutional amendment. Remember the year 2002 and 86th Constitutional Amendment Act. That's something that you have to keep in mind. And this fundamental right is available to all children, not necessarily the Indian citizens only, to all children who are in the age group of 6 to 14 years. Not just that, it is the government which is legally bound to ensure not just the admission, but also the attendance and completion of elementary education. And you have to keep in mind that elementary education is between classes 1 to 8. No student shall be denied admission for the lack of documents. And it will be the responsibility of the state government or the local governments to ensure that students are not only enrolled, but they are also attending the classes regularly and they complete the elementary school education from class 1 to 8. No child shall pay any fee. This is where it becomes very important. Is it that those students who are enrolled in government schools or those schools which are aided by the government, it is that only the school fee is not to be paid? No. The RTE Act says not just the school fee, but those expenditures involving buying textbooks or uniforms or writing materials, even this is provided to the students who are enrolled in government schools, not in the private schools, but in the government schools. But there is 25% reservation, and this is where you have to keep in mind. Is this 25% reservation in these private schools provided for all the standards, for all the classes? No, it is for class 1. All the private, even unaided schools also, they must reserve 25% of the seats in class 1 for those children who belong to economically weaker sections of the society, the disadvantaged sections of the society. These facts you have to keep in mind. Also, one more important detail. RTE Act mandates the creation of school management committees. Most of you may not be aware of this, but this is important for your exam because these school management committees were in the news, more specifically in Delhi. School management committees are to be set up. And what will be the job of the school management committee? To monitor the functioning of these schools. And then you need to know the composition of these school management committees as well. 75% of these members must be the parents or the guardians of the children who are studying in these schools. At least 50% of the members must be women. These few facts regarding school management committees you must keep in mind. School management committee is mandated by the RTE Act and their function is to monitor the functioning of the schools. What is the brief composition that you keep in mind and move ahead? Now, one more important thing. There is also a talk of one nation, one election, or the simultaneous elections to be conducted to Legislative Assembly and to the Lok Sabha. And one argument which is presented in favor of one nation and one election is that we will spare the time of the teachers as well. Otherwise, these teachers would be all the time busy in election duty. This is something that you have to keep in mind. Prohibition of the deployment of teachers for non educational purposes. This is mentioned in the law. In fact, this law says that the private tuition by these teachers is also prohibited, and teachers cannot be deployed for non educational purposes, but then there are exceptions. In some areas, teachers can be deployed for non educational purposes. And which are these areas? Census exercises to be carried out. And this is where it becomes important. Disaster relief duties and duties relating to the elections. Whether the elections are conducted to the local authorities, state legislatures, or the parliament. These are the three areas in which the teachers can be deployed for non educational purposes: disaster relief, census, which is conducted every 10 years, as well as elections. Something else. This is the question on your screen. Under the RTE Act, who has the authority to develop and enforce standards for training of teachers? Let me know what is the right answer. Under the RTE Act, who has the authority to develop and enforce standards for training of teachers? Most of you have said C, because education is in the concurrent list. No, the answer is A. Specifically, the law mandates, the RTE Act mandates that it is the responsibility of the central government to develop and enforce standards for the training of the teachers. So it is not C, it is the central government. And you need to keep in mind that education originally was in the state list, but it was migrated from state list to concurrent list when the 42nd Constitutional Amendment Act 1976. That's something that you have to keep in mind. Let's look at topic number two: restatement of values of judicial life. Now, Justice Yashwant Verma was in the news. Even right now, he is in the news. Maybe he will become the first ever judge to be removed by the president based on the recommendations, based on the resolution passed by both houses of the parliament. So, how is the judge removed from his office? That can be important. But if we link it slightly differently with something else, restatement of judicial values or judicial life, restatement of values in judicial life, is this something which is a statutory requirement? Can you tell me in the comment section? Is it a statutory requirement, which means provided by any law enacted by the parliament? No. Then what is the origin of this restatement of values in judicial life? The origin is the 1997 full court resolution of the Supreme Court, which means all the judges of the Supreme Court, headed by the Chief Justice of India, they came together in 1997, passed a resolution that we will abide by restatement of values in judicial life. I have extracted 4 or 5 very important points from this PDF, which can be important for your upcoming prelims examination. According to these values, a judge should not contest the election to any office of a club or a society or other association, and you should not hold any such elective office except in a society or association which is connected with the law. Which means, can a judge become the president of a resident welfare association or any society or any club? No. This is to detach the judge from other aspects of the societal life. But yes, the judge can become, let's say, the head of a university. The judge can also become the chairman of the governing council of a law university. So if there are associations which are related to, connected with law, only there can the judge get elected or judge can hold a post. Otherwise, no. This is mentioned where? In these rules, in these values. Second, a judge should not permit any member of his immediate family, if that member is the member of a bar, if your son or daughter-in-law or son-in-law, they're also the members of the bar. Bar means the advocates, the lawyers, the advocates on record. They cannot appear before the judge. Why? Because then there is a conflict of interest. No member of his family who is a member of the bar shall be permitted to use the residence in which the judge actually resides. So if I am a judge, my family members, my son or daughter, if they are also the members of the bar, they cannot reside with me. But this only applies to bar. It does not apply to bench, which means if my spouse is also a judge, we can share the same residence. But if my daughters, sons, they are the members of the bar, or they cannot reside with me. A judge is expected to let his judgment speak for themselves. The judge shall not give interview to the media. And we have seen a lots and lots of interviews last year conducted, carried out by various judges as well, the former judges as well, the former Chief Justice of India as well. Although after retirement, there is no such limitation. But while you are in office, you don't have to defend your judgment in the media. You will have to let your judgment speak for itself. These are important values that are part of this PDF. But not just that. These are only illustrative, but not exhaustive. Whatever is mentioned in these restatement of values in judicial life, that does not mean the judges will have to follow only these values. These values are only illustrative, they're not exhaustive. In a sense, if you want to become a member of the Rajya Sabha, the President of India may also nominate you. If you have made significant contributions in the field of art, literature, science, social service, so if there is an individual who has made brilliant contributions to these areas, such an individual can be nominated by the president to the Rajya Sabha and he or she can become the Rajya Sabha MP from the nominated route, from the nominated category. But this is only an illustrative list. That does not mean a sports person cannot be nominated to the Rajya Sabha. For example, Sachin Tendulkar was nominated to Rajya Sabha from this nominated route because this list, art, literature, science, social service, is only illustrative list, not the exhaustive list. Similarly, these values mentioned in this restatement of values in judicial life, these are only illustrative, these are not exhaustive. That means you have to do everything which will ensure the credibility and dignity of the office that you're holding. You can't do anything which is unbecoming of a judge because that's how the perceptions would change. That's topic number two. Topic number three, here is this farmer's leader, Mr. Jagjit Singh Dalibal. He was on fast, and then when the matter reached the court directed the government that he should take the farmer to the hospital, but don't let him break his fast. What is the status of hunger strike in India? Is hunger strike allowed or criminalized in India? Hunger strike is valid. Valid in the sense it draws its significance from Article 19(1)(a) of the Constitution, which is freedom of speech and expression. You want to express yourself. Also, you want to assemble peacefully at a public place without arms. So the requirement is if I want to sit on a hunger strike, yes, I have to seek the permission of the police. And if I sit on the hunger strike, I also have to ensure that there is no violence in this strike, that we do not disturb public order because of this strike. So hunger strikes, they are legal. And this is where the Supreme Court and various high courts, particularly the Madras High Court, have repeatedly clarified that hunger strikes has the Gandhian values ingrained into it because Mahatma Gandhi would also sit on fast. So hunger strikes are not unconstitutional. But I'll tell you something which is very important. The Bharatiya Nyaya Sanhita, which replaced the Indian Penal Code, it has a section called Section 226. It criminalizes fast unto death. For example, Anna Hazare goes on fast unto death. Why? Because you want to pressurize the parliament that you should enact a strong anti corruption ombudsman law called the Lokpal. Is this allowed now? No. Why? Because there is a specific sanction and section in the Bharatiya Nyaya Sanhita which says whoever attempts to commit suicide with the intent of compelling or restraining any public servant from discharging his duty. So you are going on hunger strike. Why? Because you want to compel a public official from doing something or you want to restrain him from doing something. If for that you are going on fast unto death, which means you are committing suicide. And this is something which is criminal. But, sir, attempt to suicide, is it not decriminalized now? There used to be Section 309 of Indian Penal Code, which criminalized attempt to suicide, which means if I commit suicide, I'm dead. If I attempt suicide and I survive somehow, I will be declared a criminal. But Bharatiya Nyaya Sanhita does not criminalize attempt to suicide, which means Bharatiya Nyaya Sanhita says if you are attempting suicide, you are in search of compassion, you are in need of care. And this is exactly what is mentioned in the Mental Healthcare Act as well of 2017. So, attempt to suicide is no longer a crime in India because of the Mental Health Care Act, because Section 309 of Indian Penal Code is no longer valid. But there is one form of attempt to suicide which is criminal. If you are going on fast unto death, if you are trying to commit suicide with this intention that you want to pressurize the public officials from doing something and you want to restrain them from doing something, this is a criminal offense. Which is why this section 226 of the Bharatiya Nyaya Sanhita effectively criminalizes the fast unto death tactic which is used by activists to demand policy changes. For example, a new law or a change in law. For that, I will go on fast unto death. No, this is not valid because you are pressurizing or refraining the public official from performing their duty. And link it with the Mahatma. Mahatma Gandhi first went on fast unto death. When was it? I think the year was 1918. The Ahmedabad mill strike. And after that, after communal award as well, the McDonald's, Ramsay McDonald Award, which provided reservation to the depressed classes, separate electorates to depressed classes. That's also when Mahatma Gandhi went on fast unto death. So, attempt to commit suicide with this intention that you want to refrain a public official from performing a duty is a criminal offense under Bharatiya Nyaya Sanhita. Right? Great. Now, this is where it becomes interesting, a right to life and right to die. Right to life is a fundamental right under Article 21 of the Constitution, under Part 3 of the Constitution. It's a fundamental right. But if you have right to life, do you have right to die as well? Initially, the courts were of the opinion that if you have right to life, the corollary is you should have right to die as well. This was said by the Supreme Court in 1994 in Rathinam case. You don't have to remember these case names right now, not relevant for the prelims. But in Gyankor case in 1996, the Supreme Court said no. You have right to life, but you don't have right to die. Then came Aruna Shanbag case where Supreme Court ruled right to life, but with dignity. And this is where Supreme Court legalized what? Passive euthanasia. Then came a landmark judgment of the Supreme Court in 2018 known as common cause. And in that case, Supreme Court said right to die with dignity is also a fundamental right under Article 21 of the Constitution, right to die with dignity. And this is where the Supreme Court said right to living will is also a fundamental right. And that is what we call advanced medical directive. Right to living will. So, long story short, there is passive euthanasia, which is allowed in India. Advanced medical directive is allowed. Right to living will is allowed, but right to die is not. Right to die with dignity is. This is where it becomes interesting because of Harish Rana case. The matter is before the court, and I think next week the judgment will be delivered by the court. So keep that in mind. Very important case. Harish Rana was a student, and ultimately he fell from, I think, the fourth floor, fourth story in Chandigarh. and now he's in a permanent vegetative state for more than a decade. That if passive euthanasia is allowed, then why is this individual still alive? His parents, who have spent their entire savings in giving medical care and attention to their son, they have approached the court and asked the court that since passive euthanasia is allowed, please have mercy on our son. We want to kill him. Passive euthanasia is allowed. But the court did not rule in their favor. Why? Because they approached the court that Ryle's tube should be removed. But what is this Ryle's tube? A small plastic tube is inserted into the nose from where it enters the stomach. This is where Harish Rana was being fed food. So the parents argued that we want to remove this Ryle's tube so that we don't have to feed this individual and ultimately he will die. But the court said this would amount to suicide or this may amount to death by starving. Passive euthanasia is where an external device is used to keep the patient alive. Since Harish Rana was not on and is not on a ventilator support, external mechanical support, if he was on an external support, ventilator support, we may have asked the doctors that you remove this so that this person can die with dignity. But since he is not, he is being fed through this Ryle's tube. This is not an external mechanical device to keep the individual alive. But now the court has decided we will hear this case again, and maybe next year on 15th, next week on 15th almost, this decision will be taken by the Supreme Court. So this is something that you have to keep in mind. Removing of a Ryle's tube, which is used to feed an individual, may not amount to passive euthanasia. Passive euthanasia is when an external mechanical device, such as a ventilator support, is withdrawn and the patient dies. That's the distinction that you have to keep in mind. Okay, great. Let's look at topic 4. In 2025, there was a review petition which was dismissed. And this review petition was filed against the Suprio v. Union of India 2023 case. It was in this case, and this case was about whether LGBTQ community, they have the right to marry the person of their choice as well. Supreme Court said right to marry is not a fundamental right. And this is the often asked doubt of a student. Sir, is the right to marry a fundamental right or is right to marry the person of one's choice a fundamental right? Because in Hadia case in 2019, Supreme Court had said right to marry is a fundamental right. So what is the current legal status of right to marry? Is right to marry a fundamental right? Or is right to marry the person of one's choice a fundamental right? Is there any difference between the two? Keep one thing in mind. Supreme Court, the Constitution Bench judgment of the Supreme Court in Suprio v. Union of India in 2023 said right to marry is not a fundamental. If at all the right to marry is to be provided, that will be provided by the law enacted by the legislature. It is not guaranteed by the Constitution. The court clarified that previously, for example, in Hadia case and in various other cases, where we have said right to marry is a fundamental right, that only means that right to marry a person of one's choice without any fear or coercion is a fundamental right, which means you can't be coerced into marrying somebody or you can't be threatened into marrying somebody. So right to marry the person of your choice, if you're an adult, you can't be threatened, you can't be coerced. That's your fundamental right. But the abstract concept of right to marry is not a fundamental. Long story short, review petition was filed and review petition was dismissed. Is review petition something which is mentioned in the Constitution? Does it have a constitutional backing? You need to keep in mind, yes. Because Article 137 of the Constitution gives the revisory power or revisory jurisdiction to the Supreme Court. Supreme Court has the power to review its own judgments, and the relevant article is Article 137 of the Constitution. But for that, you need to file this review petition within 30 days of the judgment. And this review petition will be accepted if an error has been pointed in a judgment, or if new facts have been discovered. So a review petition will be accepted by the court if new fact has been discovered in a case or if an error has been pointed out in the original judgment. And you have to file this review petition within 30 days of the judgment. And the same judges who heard and dismissed your case, they will have to hear your review petition as well. These are facts which are very important for review petition. Review petition is in the news, and also because of the presidential reference under Article 143, which we will also discuss slightly later. Then comes curative petition. Is there any time limit within which curative petition can be filed? No. But the rules only say within a reasonable time period. After the review petition is dismissed, within a reasonable time period, you can file a curative petition. Now, is this curative petition which has a constitutional status, which is provided in the Constitution? No. Review petitions have constitutional sanctity, but not the curative petition. Curative petition is something which has been evolved in India because of a judgment known as Hurra v. Hurra, 2002. And the grounds for accepting or filing this curative petition are also very narrow. Grounds such as you have to say that principles of natural justice have been violated. You have to say that this judgment has adversely affected you, adversely affected the petitioner, or that the judge was biased. On these narrow grounds, you can file the curative petition. But this curative petition will be heard by three senior judges of the Supreme Court, plus the judges which dismissed your review petition. And ultimately, it will be decided. So, what is the difference between review petition and curative petition? Review petition is filed within the 30 days of the judgment. Curative petition is filed after the dismissal of the review petition and within a reasonable time period. Review petition is filed, but you have to prove or you have to convince the judges that there is an error in your judgment or new facts have been discovered in this case. And the same judges which heard your cases, the same judges will have to hear review petition as well. But curative petition will be heard if these grounds are satisfied, very narrow grounds, and will be heard by three senior judges of the Supreme Court, plus those judges who dismissed your review petition, who dismissed your previous petition. And the success rate of this curative petition is less than 0.5% in India. And curative petition was in the news throughout the last 2 to 3 years, more specifically in the Union Carbide case, as well as in the Delhi Metro Rail Corporation case, famously known as the Anil Ambani case. So that is what you have to keep in mind. Know the facts and the differences between the two. You're more than sorted. Topic number 6. Is India open to an idea of dual citizenship? Articles after articles were written in Indian Express and the Hindu, in Hindustan Times as well. Dual citizenship. The problem in Assam, the SIR that we are conducting, the Election Commission is conducting, all these have raised significant questions on citizenship. So, citizenship becomes a very, very important topic for your upcoming prelims examination. We have single citizenship in India. And we also have a single domicile. What is your domicile? You are a domicile within the territory of India. One single citizenship, one single domicile. Keep that in mind. Do we have dual citizenship? No, but there is an exception. Exception is if there is a child and this child is born outside India but to Indian parents. Requirement is that the child should be born not within the territory of India but outside the territory of India, but born to an Indian parent. Let's suppose my child is born in United States, and in United States they follow a concept of yas soli, which is law of the soil. Whoever is born on the soil of United States is the citizen of United States, which means my child is the citizen of United States. But the parents are Indians. Can this child also become the citizen of India? Yes. Can this child will have a dual citizenship? But we don't have dual citizenship. Only for this child there is dual citizenship. That means a child born to Indian parents outside the territory of India in a country which respects, values, and follows dual citizenship, this child will have a dual citizenship, but only till the age of 18 years. Once this child completes 18 years, you have 6 months to decide whether you want to continue the citizenship of that country or you want to continue with the citizenship of the Indian nation. And if you are unable to decide, your Indian citizenship will be terminated. So that is the logic of dual citizenship. Whether we should embrace dual citizenship or not, that will be the discussion in the mains examination, but not for prelims. For prelims, this is the only way, this is the only instance where dual citizenship is recognized. But then, citizenship as a topic becomes important. And for that, we need to discuss three ways in which citizenship can be lost, because these were in the news over the past 1 to 1.5 years, primarily because of the special intensive revision carried out by the Election Commission of India, which we will discuss tomorrow. But the point is, if you are a citizen of India, you can be a citizen of India by birth or descent or naturalization or registration or incorporation of a foreign territory. Now, the doubt that a student had, the doubt was if tomorrow India acquires a territory X, does that mean all the people who are inhabiting this area will automatically become the citizens of India? No. It is for the central government, because citizenship is under the union list and the required ministry is MHA, which is the nodal ministry for all citizenship matters. It is for the central government to specify which of the citizens inhabiting and residing in X will become the citizens of India. So it is not that if India acquires a territory X, automatically all the citizens of that area will become the citizens of India. No, the central government will have to specify. But then there are three ways in which you can lose your citizenship. One is by renunciation. Renunciation is a voluntary act. I want to voluntarily give up my Indian citizenship. You can do that. But here again, it is interesting. If I'm renouncing my Indian citizenship at the time of the war, it is not binding for the government to accept this. The government may say, because of the war, we are keeping it pending. We will see to it after the war is over. And if a man of full age and capacity, if you are mentally insane, your renunciation will not be accepted by the government. If you are a minor, your renunciation will not be accepted. These are the facts that you have to keep in mind. Renunciation can be done by a person of full age, 18 plus, and capacity. That means you should not be insane. But if a man or if a citizen gives up voluntarily, renounces the Indian citizenship, the minor kids will also lose their citizenship. This was in the news. That is why we are discussing this. But the point is, what if this minor loses the citizenship because the parents have renounced the citizenship? What if once this child becomes a major, attains maturity, 18 years, can this child resume Indian citizenship? Yes. You only need to declare that I want to resume my Indian citizenship and thereupon again become the citizen of India, which means you don't have to spend time in India. You don't have to fulfill the condition that you have to stay in India for 5 years or 7 years. After you have declared, because you were once the citizen of India, but your parents renounced their citizenship. Now I have completed 18 years of age and I want to make a declaration that I want to resume my Indian citizenship. Once I do that, government accepts, I can resume my citizenship. I don't have to wait for 5 or 7 years or 14 years to resume my citizenship. That's something that you have to. Second is by termination. If an Indian acquires the citizenship of another country, the central government may terminate your citizenship. But again, this is not automatic. Important term here is automatic. There is no automatic termination of citizenship. The central government will have to terminate your citizenship if they come to know that you have acquired the citizenship of another country. The third is deprivation. Listen to me carefully. Can an Indian who is a citizen by birth be deprived Indian citizenship? No. Then who can be deprived Indian citizenship? If you have acquired Indian citizenship through registration, if you have acquired citizenship through naturalization, if those individuals who have acquired citizenship through registration or through naturalization, but later the central government realizes that you obtained this citizenship through fraud, through concealment of facts, through misrepresentation. For example, in order to become the citizen of India through naturalization, you should have ordinarily stayed in India for 14 years. You should be well versed in a language mentioned in the eighth schedule of the Constitution. You should not be from a country where Indians are not allowed to become citizens. And you should also make your intention clear that you want to make India your permanent home. So there are some conditions which you need to fulfill. Only then you can become the citizen through registration or naturalization. And if the central government realizes that you have acquired Indian citizenship, fraud, concealment of facts through misrepresentation, then your citizenship can be you're deprived of Indian citizenship. Or if the citizen who has acquired citizenship through registration or naturalization, but later on you are acting in such a manner that you are disloyal to the Constitution of India, you're promoting disaffection against the Constitution of India, your citizenship, or you became Indian citizen through registration and naturalization. But now that there is war with China, for example, you're doing business with China, you're interacting with China, and maybe you're also assisting this enemy country during the war, your citizenship will be deprived. Or you acquired citizenship of India through registration and naturalization, but within 5 years, you were sentenced in any country, not just in India, in any country. In any country, if you were sentenced for a term of not less than 2 years, your citizenship. And if such a citizen who has acquired citizenship through registration or naturalization, if you have been continuously out of the country for 7 years, that too, when you are not a student, when you are not working for the government of India in any agency, or when you don't every year communicate to the foreign embassy in Indian embassy in foreign country that I want to retain, my intention is, even if I'm outside the country, but I want to retain my Indian citizenship. If you have not done that, your citizenship there. There is an Indian who is an Indian through naturalization or registration. But now you are out of the country continuously for a period of 7 years. But you're not a student. If you're a student, you're saved. You are working for the government of India, you are safe. You are working in any agency of the government of India, you are safe. Or even if you're outside of the country, but you go to the embassy every year and tell them, my intention is I want to retain my Indian citizenship. If you're not doing any of this, we can assume that you are no longer interested in continuing with the citizenship of India and we will deprive you of Indian citizenship. But again, it's applicable on those citizens of India through registration or naturalization. One more important thing, Assam Accord. Because of the Assam Accord, because you would know between 1979 to 1985, there was a movement in Assam where protesters wanted that illegal migrants should be thrown away. Illegal migration is another hot topic in India these days. In response to that, Assam Accord was signed between the government of India, the state government, and the protesters, led by all Assam Student Union. And Section 6A was added to the Citizenship Act of 1955. And this Section 6A of the Citizenship Act was upheld by the Supreme Court 2 years ago. This is where it becomes important. Normally, what happens, and listen to me carefully, the cutoff date for citizenship is 19th July 1948. If you have entered India before 19th July 1948, you are the citizen of India. But for Assam, the cutoff date is different. If you have entered Assam between January 1st, 1966 till the midnight of 24th of March 1971, you will be struck off the electoral roll. For these 10 years, you cannot contest elections, you cannot vote in the elections. And after that, you have to register to become the citizen of India. But whoever has entered India on or after 25th of March 1971, those are to be identified, arrested, and deported. These are the facts that you have to keep in mind. But in this act, there is a term used called a person of Indian origin. If a person of Indian origin has entered Assam and resided in Assam between 1966 to 1971, or a person of Indian origin has entered Assam after 25th March 1971, what is the definition of this person of Indian origin? That's something you have to keep in mind. And the definition is, if you or your parents, either of your parents or any of your grandparents, were born in undivided India. Undivided India includes Pakistan and Bangladesh. If you were born in undivided India, or your parents were born in undivided India, or your grandparents or any of them were born in undivided India, you are a person of Indian. That's something that. Any questions as of now? Anyone with any questions? Then we can continue. Great. Topic number 9, governor as the chancellor of state universities. The controversy surrounding Tamil Nadu, West Bengal, Kerala, and many other states, primarily ruled by the opposition. This role, that governor is the chancellor of state university, is it provided in the constitution? No. This is provided by the laws passed by the state legislature. And the origin is the colonial government. In 1857, the British established the first three universities in India, the initial ones in Calcutta, Bombay, and Madras. And then governors of these respective provinces, they were appointed as the chancellors of these universities. Why? Because the British wanted to exert control over these universities through their agent, who is the governor. And that is how, as the governor, who also became the chancellor of state universities. And as the chancellor of state universities, you will appoint the vice chancellor. You will appoint members to the university bodies. And you will also be presiding over the convocations of these universities. If the governor is the chancellor of state public universities, which means the government universities, president of India is the visitor of central universities. That's something that you have to keep in mind. But not just this. Punchi Commission, which was set up on center state relations in 2007, it had recommended that governor should only play a constitutional role, which is the constitutional head of the state. You should not be presiding over this role of the chancellor of the state university. No. It was this Punchi Commission which had suggested that states should appoint exceptional academics, experts as the chancellors, so that the academic independence of that university is ensured and conflicts can be minimized or eradicated, the conflicts between the union government and the state government. And for that, you have to keep in mind UGC rules for the appointment of the vice chancellor. Although, because the news is regarding the draft guidelines for the appointment of vice chancellors. This is very important. According to these rules, although draft rules have not come into force yet, these are only draft, but according to the existing rules, a vice chancellor should be a distinguished academician with 10 years of experience as a professor in a university or 10 years experience in a reputed research or academic administrative organization in the research institutes, Tata Institute of Fundamental Research, Indian Institute of Science. So even if you are not a professor with 10 years experience, but a researcher in a reputed research institute, you are eligible to be appointed as a vice chancellor. Draft guidelines say that you can have 10 years experience in industry, which means industry veterans, corporate honchos may also be appointed as the vice chancellors. That is why there is a conflict between the union government and the state government. State governments are alleging that you're violating the independence, the academic independence of these universities by appointing a non academic, a non professor as the vice chancellor. These draft guidelines are not yet in force. So the current status remains. Vice chancellor should be a person with 10 years of experience as a professor or 10 years experience in a research institute. But for example, there is this University X. Who appoints the vice chancellor of that university? The chancellor, who is the governor. But how will the governor appoint the vice chancellor? First, a search cum selection committee will have to be set up, which will prepare a list of 3 to 5 names. Search and selection committee will be set up, and this search and selection committee will look into different names and finally come up with 3 to 5 names. And one from this list will have to be appointed as the vice chancellor of that university by the chancellor. But members of this search and selection committee should be eminent members in higher education. They should not be connected with the university. This is where the controversy was. State governments are also part of this search cum selection committee. Let's say a minister of education may be part of it. But draft guidelines, they remove the role of the state government. And that is why it was considered to be against federalism. And federalism is part of the basic structure of Indian constitution. I'm going very fast, which I know, but I have the assumption. My assumption is that you have covered all the static portion, and now you just want to understand the current affairs part of it. But if you have questions, you can ask me towards the end, because we have to cover a lot of issues in the shortest possible time frame. That's why we are discussing it slightly fast. Okay, great. This vice chancellor has a 5 year term. Usually, there is an age gap. That is, you should not be beyond the age of 70. No second term at the same university. But the vice chancellor can be appointed to this university and then he can be appointed to any other university as well, as the vice chancellor of that university as well. But same second term at the same university? No. Although there have been instances of extension. Extension could be provided, but not the second term. Right? Let's look at topic number 10. Uttarakhand live-in relationship. Uttarakhand, apart from Goa because it was a Portuguese colony, they have some form of uniform civil code. And Uttarakhand also has a uniform civil. Why? Because if uniform civil code is part of directive principle of the state policy, and it is the responsibility of the state to implement directive principles of the state policy, because directive principles are positive obligations on the states. And the definition of the state includes state governments as well. The Uniform Civil Code is not necessarily to be implemented by the parliament throughout the country. It can be implemented by the states as well, because the obligation is on the state under Article 12. And Article 12 state includes state governments. State governments can also enact uniform civil. Uttarakhand has done that. Also because family or laws related to marriage or civil procedure or criminal procedure, they are mentioned where? In list 3, which is the concurrent list. So these are the facts that you have to keep in mind. Apart from that, I don't expect a direct question on what are the features of Uttarakhand's live in relationship or uniform civil code. Just these facts are important. But I'll still, because you never know UPSC, U stands for unpredictability. I'll briefly take you through some of the features of this live in relationship concept in Uttarakhand, because this matter is before the court and may be asked. Chances are less, but you never know. The Uniform Civil Code in Uttarakhand mandates compulsory registration of opposite sex live in relationship and criminalizes unregistered non marital cohabitation, which means if you have to go for a live in relationship, you will have to register. If you don't register, it is a crime. But this Uniform Civil Code in Uttarakhand declares that if a child is born out of this live in relationship, the child will be a legitimate child. Because previously, if a child was born outside of the wedlock, the child was considered to be illegitimate. And as an illegitimate child, you did not have the uh, inheritance laws in your favor, could not inherit the property of your father. Uniform Civil Code offers maintenance rights for individuals who are deserted by living relationship. So, boy and a girl, they're in a living relationship, but the boy suddenly deserts, leaves this woman high and dry. Maintenance has to be provided. But this live in relationship can also be terminated by either of the two parties. A live in relationship can be terminated simply by submitting a termination statement. So, unilaterally, the boy can terminate the live in relationship, that is also allowed. But this live in relationship can be entered into only by heterosexual couples, not by those who are in same sex relationship. So, lesbian, gay relationship in a live in relationship is not supported by the Uttarakhand model of Uniform Civil Code. Although there have been questions raised, questions such as you have to inform the police as soon as you enter into a live in relationship. Or if the age of a person who wants to enter into live in relationship is less than 21, you have to inform the parent or the guardian of that individual, which is considered to be violation of the Supreme Court case in Shakti Vahini v. Union of India, where in this case Supreme Court upheld sexual autonomy of individuals. But be that as it may, few facts related to this, although may not be asked, but you never know. But these are the things that you have to keep in mind when it comes to Uttarakhand UCC. Okay, great. Let's look at topic 11, arresting women at night. You might have read that police cannot arrest a woman after sunset and before sunrise. Is this a mandatory provision or is it only optional? That's something that you have to keep. There are two safeguards provided under Bharatiya Nagrik Suraksha Sanhita, and BNSS replaced what? Criminal Procedure Code. What are these two safeguards? Number one, no woman shall be arrested after sunset and before sunrise. You cannot be arrested except in exceptional circumstances. But what are these exceptional circumstances? These are not defined. which means who has the discretion in deciding whether it is an exceptional circumstance or not? The police. But the second safeguard is if this woman has to be arrested even after sunset or before sunrise, women police officer should give it in writing to the magistrate, to the nearest magistrate, that we want to arrest this woman after sunset and before sunrise. And you have to submit this written report to the magistrate. And without magistrate's approval, you cannot arrest that woman. These were the safeguards. Long story short, the current position is the courts have said that these are only voluntary provisions. Because what if the police arrests you if you're a woman after sunset and before sunrise? Ideally, there should have been a punishment prescribed in the law that if the police does that, this is the punishment for the police. Since no such punishment is provided, which means the law makes it voluntary. Otherwise, there would have been consequences for the police if they don't comply with this provision. And that is why we say this is a voluntary provision and not a compulsory provision. Because the courts have said, what if this woman is at a flight risk? What if she wants to run away from the country? What if she wants to tamper with the evidence? What if she wants to threaten the witnesses? In that case, the system would slow down, and obtaining the permission of the magistrate would slow down the proceedings, the investigation in this case, and the woman may run away from the country. Long story short, what is the current status of arresting women at night? Ideally, a woman should not be arrested after sunset and before sunrise, except in exceptional circumstances. And which are these exceptional circumstances? Not defined. That's for the police to decide. And the woman police officer has to submit a written report to the nearest magistrate asking the approval to arrest that individual. And once that is taken care of, the woman can be arrested. Clear? Topic number 12, governor's powers. This is in response to the judgment given by the court in April 2025, because the period of current affairs that we are covering in this lecture is between January to June 2025. In April, a two-judge bench of the Supreme Court gave a verdict. And you would know the history. Bills passed by the state legislatures in Tamil Nadu, not signed, assented to by the governor, matter went to the court. And the Supreme Court said that Tamil Nadu governor, you have withheld assent to 10 bills passed by the state legislature. And since you have done that, that is illegal, erroneous. And as such, all these 10 bills were deemed to have been passed. And for the first time in the history of independent India, bills were enacted, came into force, into laws in Tamil Nadu without the explicit assent of the governor. And then you would realize after that, the matter went to the court in the form of a presidential, which we will discuss. But let's understand this governor's power in slight detail. Once a bill is passed by the state legislature and sent to the governor, what are the options available with the governor? The governor can grant assent to this bill, which means the bill is signed, it becomes a law. Or the governor can withhold assent. The governor may publicly declare that I'm not going to sign this bill. And in state of Punjab versus Principal Secretary to the Governor of Punjab 2023, Supreme Court said that does not mean when the governor publicly declares that I'm not going to sign this bill, that means the bill is dead, it can never become a law. No. Immediately when you withhold assent, the governor has to send this bill back to the state legislature for reconsideration. You have to submit your objections to this particular bill. And if the same bill is passed again by the state legislature, governor has no other option but to sign this bill. That's option number two. Absolute veto and suspensive veto were merged together by the court in Punjab case in 2020. And in the Tamil Nadu case, Supreme Court said you have three options, dear governor. Either sign or say I'm not going to sign. And when you say I'm not going to sign, you immediately send the bill back to the state legislature. And if they pass it again, with or without considering your objections, you have no other option but, or you can use third option and reserve the bill for the consideration. These are the only three options available. There is no such thing as pocket veto. There is no pocket veto. Further, a bill reconsidered by state legislature cannot be reserved for the president. This is what Mr. Ravi was doing in Tamil Nadu. Bill has been passed by the state legislature, sent to the governor. Governor is sending this bill back. Same bill is passed again. Now the governor is using the option, reserving it for the consideration of the president. Supreme Court said, no, you can't do that. You can do this if it is a different bill. Different bill in the sense, if the legislature has made fresh changes into this bill, then you can reserve it for the president. But if the legislature has made no change or has made only those changes which you suggested, then it is not a new bill, it's an old bill. And once it is presented back to you, you have no other option but to sign. That is where we will. Now, if a bill has been passed by state legislature, but Council of Ministers advise the governor, don't sign this bill, then in that case, you have to take this decision and return this bill to the legislature in 1 month. Which means I am the chief minister and council of ministers. I'm advising the governor, don't sign this bill. The governor may not sign this. But if you don't want to accept my advice, you have to send this bill back to the state legislature within 1 month. If the governor has been given an advice by the chief minister and council of ministers, don't sign this bill or sign this bill, but the governor does not want to accept the advice of the council of ministers, you have to send this bill back to the state legislature. If the chief minister and council of ministers are advising the governor, don't sign this bill, that means you have to act on my advice. And the governor is accepting this advice. The governor will be sending this bill back to the state legislature in 1 month. But the council of ministers and the chief minister have advised the governor, don't sign this bill or sign this bill. This time, sign this bill. But the governor does not want to sign this. You have to send this bill back to the state legislature within 3 months. If the governor, you want to reserve this bill for the consideration of the president, you have 3 months to decide. You can't be sitting on the bills for an indefinite period. And if the same bill is passed again by the state legislature, you have to give assent within 1 month. And if you don't do that, the state government can approach the court again, and we will issue the writ of mandamus, and we will direct the governor to sign on this bill. There is something called Article 361 of the Constitution, which says no criminal action can be taken against the governor, which gives immunity to the governor and the president, which means the governor or the president may not be inquired into any court of law when it comes to the discharge of their official duty. This is the immunity. Supreme Court has clarified in April 2025 that although there is immunity available to the governor and the president, that we cannot inquire into your conduct or the official work that you're doing, but that does not stop us from examining your actions. Long story short, despite Article 361, there can be judicial. Why? Because judicial review is part of the basic structure of Indian Constitution. Once the governor reserves a bill, he must record his reasons and clearly indicate that these are my objections. And once you have indicated that these are my options, you have to send the bill back to the state legislature for reconsideration. But one thing, whether the governor, listen to me carefully, whether the governor gives assent or withholds assent or sends this bill for president for or reserves this bill for the consideration of the president, These are all discretionary powers of the governor. But in one case, it is not discretionary, it is mandatory. If the state legislature passes a bill which violates or derogates the powers of the High Court, snatches the powers of the High Court, such a bill passed by the state legislature necessarily, compulsorily has to be reserved by the governor for the consideration of the. And the same principle, the Supreme Court said, timeline applies to the president as well. Under Article 201, because Article 200 is when a bill is presented to the governor. Article 201, when the governor reserves a bill for the consideration of the president. The president has only two options when a bill is presented to her. Either you grant approval or you withhold assent. If you have given assent, then there is no controversy. If you have withheld assent, then the president, once she withholds her assent, this bill is sent to the legislature again through the governor. And then the state legislature will have to reconsider that bill within 6 months. But when the same bill is passed again, whether considering the objections of the president or not, but once this bill is given again to the governor, governor will send it to the president. But there is no obligation on the president to give assent to such a bill. That's Article 20. So, what are the options available with the governor when it comes to a bill passed by the state legislature? Either the governor gives assent or the governor withholds assent. But if the governor withholds assent, you have to send the bill back to the state legislature for reconsideration. Or the governor may reserve a bill for the consideration of the president. These are the only three options. And then there is a timeline. If the government is advising the governor that don't sign this bill, that means you have to act on the advice of the Council of Ministers. And if the governor says, okay, I'm not signing this bill because you have advised me, even then the governor will have to send this bill back to the state legislature within 1 month. But if the governor is advised by the Council of Ministers, sign this bill, but he says, no, I'm not going to sign this bill. Even then, within 3 months, you have to return it to the state legislature. Or if you don't want to return it to the state legislature, you want to reserve it for the consideration of the president, do that within 3 months. But if the bill which you send to us back, state legislature, if we pass the same bill again, you have 1 month to sign this bill. If you don't, we will go to the High Court, we will go to the Supreme Court, they will issue mandamus, and you will have to sign. When you reserve a bill for the consideration of the president may either give assent or withhold assent. If she withholds the assent, you have to send this bill back to the state legislature. And then state legislature has 6 months to decide on that bill. But if the same bill is passed again, the president is not bound to. Then when this judgment was given by the court, look at the practice question on your screen. Article 142 was used by the court. And Supreme Court said, we will do complete justice in this case. And the complete justice is all those 10 bills which were passed by the Tamil Nadu state legislature and were not signed by the governor, we will declare that these bills have been deemed to have been assented by the governor. That's where the concept of deemed assent came into the picture. Now look at the question on your screen. And this was under Article 142, where Supreme Court can give any order so as to give complete justice. Take a look at the question on your screen and let me know what is the right answer. Why and when will ministers ask to not sign the bill to the governor? What if it was a private member's bill passed by the state legislature and the government does not want to get this bill implemented? Or what if this bill was passed, but then the government changed and this bill is pending with the governor, and now the new government is telling the governor, don't sign this bill. And if the governor says, okay, I'm not going to sign this bill, even then you have to send this bill back within 1 month. Under Article 142 of the Constitution, the Supreme Court has the power issue such order as is necessary for doing complete justice. Under Article 142 also, to make any order for the purpose of securing the attendance of any person, discovery or production of any documents, or investigation or punishment of any contempt of itself. This is also covered under Article 142. We can issue any order and we will ask that person to be brought before, any document to be presented before us. That's Article 142. Both these statements are correct. C is the right answer. Okay. Let's look at topic 13, presidential reference. You would know under Article 143, Supreme Court acts as the advisor of the President of India. The President may refer any matter to the Supreme Court, asking the views of the Supreme Court on this matter. But you have to keep in mind, this matter can be pre-constitutional or post-constitutional. If this matter, which has been sent to the Supreme Court by the President, deals with a pre-constitutional matter, it is mandatory for the Supreme Court to give advice. But if it is a matter which deals with post constitutional issues, it is not binding on the Supreme Court to give advice. But which matter can be sent to the Supreme Court by the President? Any matter, but it should not be an ongoing litigation. For example, in the 1990s, Babri Masjid matter was referred by the President to the Supreme Court, asking the views of the Supreme Court on that matter. Since it was a post constitutional matter, Supreme Court said we won't give the advice. And primarily because this is a matter which is pending before us. On this matter, we will not give the advice. But for your prelims examination, you have to keep in mind that this provision is similar to Section 213 of the Government of India Act 1935, which gave similar power to the Federal Court of India. And since independence, how many presidential references have been issued? 15. The latest, the 15th one was the Tamil Nadu reference. But now listen to me carefully. Sir, in presidential reference in Tamil Nadu case, Supreme Court changed its position. Supreme Court said you cannot restrict the governor or the president to a timeline. You cannot issue mandamus to the president or the governor. What will prevail? Will this presidential reference prevail or the April 2025 judgment of the Supreme Court? The April judgment will prevail. Advisory opinion is only advisory, it is not binding. So, whatever opinion is given by the Supreme Court in its advisory opinion is not binding. But listen to me carefully. Can a presidential reference alter or modify the previous judgment of the court? This is the question that I'm asking you. Can the presidential reference modify, alter the previous judgment given by the court? Yes or no? Some say no, some say yes, some say no, some say yes. Majority are saying no. Listen to me carefully. In 1993, in second judge's case, Supreme Court invented collegium system. Right or wrong? Supreme Court said from now onwards, when a judge is to be appointed by the president will consult Chief Justice of India plus two senior most judges of the Supreme Court. In response to that, the president gave a presidential reference to the Supreme Court. Appointment of the judges, presidential reference 1990. In this presidential reference, did the Supreme Court say collegium system is gone? No. But what Supreme Court did, Supreme Court said instead of Chief Justice of India, two senior most judges, you should consult Chief Justice of India and four senior most judges of the Supreme Court. And right now, whenever collegium system works, whenever collegium has to meet, it is the Chief Justice of India and four senior judges of the Supreme Court. This is despite the fact that this was said by the court in third judge's case, which was a presidential reference. Is it possible? Is it allowed? Yes. You can't change the or overturn the original judgment or earlier judgment or previous judgment, but you can also always revise it, slightly modify it. Supreme Court did not say in 1998 presidential reference that there is no collegium system. No, collegium system is there, but we are now going to refine it. Instead of Chief Justice and two senior judges, we will have Chief Justice and four senior judges. That means we are not overturning the original judgment. We are just modifying it, refining it. So, can a presidential reference alter the original or the earlier judgment? It depends. Can you change the essence of the previous judgment? No. You modify it, fine tune it, revise it. Clear? Yes, fundamental changes cannot be made. Topic number 14. Maintenance and Welfare of Parents and Senior Citizens Act 2007. This was in the news. We will briefly touch upon this and be done with this article. If there are parents who are aged 60 or above and they are unable to maintain themselves from their own earning or the property which was owned by him. For example, I am 60. My wife is 60. We are unable to maintain ourselves either from our earnings or from the property which was held by us. We can file a case. Against whom? Against our kids, that you have to maintain us. If we don't have kids, relatives. That's what we call legal heirs. According to this law, there is an obligation on these kids or my relatives that you have to maintain us. You have to support us because we are unable to maintain ourselves. Because your support is required, necessary for us to lead a normal life. And to save these senior citizens, this law says don't approach the court directly because that will be time consuming. You can approach a tribunal. And if you're not happy with the award given by the tribunal, there are appellate tribunals as well. Even then, if you're not satisfied, you can go to the court. Listen to me carefully. The two of us, me and my wife, we have transferred our property to our kids. Now the kids will say, you go and leave our property because now this is our property. And they're not maintaining us properly. We can go to the tribunal and we can tell tribunal, since there is an obligation on them that they have to maintain us so that we lead a normal life and they're unable to do that, whatever property that we transferred to their names, you should assume that this property was transferred to fraud, to coercion, to undue influence, and we want that property back. This also can be heard by this tribunal. This was in the news. Just two facts related to this act is important. After that, the topic is over. Which means act allows parents 60 or above to file a case against the legal heirs or their children if they're unable to maintain them so that they can lead a normal life. And there are specific tribunals where you can approach. And if you have gifted your property, even then the kids are not maintaining you, you can go to the tribunal and tribunal will say, since you are unable to maintain them, whatever property you were given, we have to assume that that property was given through fraud, through threat, through coercion, or through influence, undue influence, and we will snatch this property back and give it to the aged. This is the law of 2007. Okay, great. Topic number 15, deputy speaker. In the 17th Lok Sabha, there was no deputy speaker. In the 18th Lok Sabha right now, there is no deputies. So deputy speaker becomes important. Article 93 says the House of the People, which is the Lok Sabha, shall, as soon as may be, which means no time limit, as soon as may be, two members will be elected. One will be elected as the speaker, the other will be elected as a deputy speaker, which means it is a constitutional necessity. This is not a discretion. The House of the Lok Sabha shall, and this word shall makes it binding. The legal term shall. The House of Lok Sabha shall, as soon as may be, elect two of its members, one as the speaker and the other as the deputy speaker. That means both speaker as well as deputy speaker, they are elected by the Lok Sabha. And they have to be necessarily the members of the Lok Sabha. It is a custom, a convention, that in the first session itself, the speaker is elected. And normally the deputy speaker is elected in the second session. But this is not mentioned in the constitution. This is not mentioned anywhere. It is a convention. And the convention also is that if the speaker belongs to the ruling party or the ruling coalition, the deputy speaker's post is invariably given to the opposition. But you also have to keep in mind that who decides, who fixes the date of deputy speaker's election? Who fixes that date? Tell me. Speaker. And do we have a origin of this deputy speaker? During the British rule, when Central Legislative Assembly originated, there was a post known as Deputy President. The first person to hold this post was Sachidanand Sinha, who later on also became the interim head of the Constituent Assembly. And the origin is 1921. And by the time we achieved independence, the Deputy Speaker was already part of governance in India. So we had Deputy President during the British rule, same person became Deputy Speaker in the Constitution of India. Clear? But not just that. Historically, this office has held symbolic importance because if the speaker is from the ruling party, deputy speaker is from the opposition, so there is a bipartisan support. And deputy speaker plays a very important role. He is not only the assistant to the speaker, he has his own constitutional understanding, or should we say the constitutional position. Whenever deputy speaker becomes a member of any committee, he becomes the chairman of that committee. That's the privilege that deputy speaker has. Look at the question on your screen and tell me what is the right answer. With reference to the deputy speaker of the Lok Sabha, consider the following statements. The Constitution mandates that the deputy speaker must be elected within 6 months of the first sitting of the Lok Sabha. No, the Constitution only uses the phrase as soon as may be. There is no time limit. The deputy speaker, while presiding over the House, does not vote in the first instance but has a casting vote in case of a tie. True. So, whenever a deputy speaker is presiding over the Lok Sabha, he has the same power and privilege as available to the speaker. The deputy speaker, like the speaker, continues to hold office even after the dissolution of the Lok Sabha. Is the third statement correct or incorrect? It is mentioned in the Constitution itself that when the Lok Sabha is dissolved, all the MPs of the Lok Sabha are gone. They'll have to resign, except Speaker. He does not resign. So the Speaker normally resigns when the new Lok Sabha is meeting for the first time. So even if the previous Lok Sabha is dissolved, now the new Lok Sabha is meeting for the first time today. In the morning, the Speaker of the previous Lok Sabha will resign. but that is not the privilege available with the deputy. It's a privilege only with the speaker, not with the deputy speaker. It is a constitutional convention in India. The deputy speaker's position is offered to the opposition. Is it? It is a convention, yes. That deputy speaker's position is offered to the opposition. Constitutional convention means what? Looking at the provisions of the constitution, have we derived some conventions, unwritten rules? Yes. Two or four, two statements are correct. Right? It is a convention. It is not a constitutional provision, but it is a convention. The convention is that the deputy speaker's post is given to the opposition. Question number 16, or topic number 16, private members' bills. Recently, we saw the right to disconnect bill, which was introduced by a private member, Srimati Supriya Sule from NCP Sharad Pawar. This is where private members' bills become important. What is a private member bill? A bill which is introduced by a non minister is a private member's. Can an MP belonging to the BJP introduce a private members bill? Yes, because not all the members of the BJP are ministers. Any bill introduced by a minister is a government bill. Any bill introduced by a non-minister, whether this non-minister is from opposition or from the ruling party, doesn't matter. It's a private member. You have to keep in mind rules of the Lok Sabha, that private members' bills are usually scheduled for discussions on Fridays in the parliament. So every Friday, there is a provision that if a private member wants to introduce a bill, he can introduce a bill after getting approval of the Business Advisory Committee. Clear? But the current challenges are increasing disruptions. So whenever parliament is disturbed or disrupted, Fridays, which were meant for private members' business, Fridays are also used for the government business. Only 14 private members' bills have become laws since the enactment of our constitution. Can you name the last one? The last one was Supreme Court enlargement of criminal appellate jurisdiction. This was the bill which was passed in 1970. This was the last private members bill which became act. Otherwise, since then, no private members bill has become an act. Despite the fact that the rights of transgender persons bill, it was introduced as a private members bill. But later on, the government convinced the private member that you drop your idea, we are going to bring a government bill. And then that government bill became the act in 2009. The last time that a private member's bill was passed was in 19. Okay, great. Topic number 17, POCSO, Protection of Children from Sexual Offences of 2012. There are there are a couple of articles on POCSO in today's The Hindu newspaper as well. This law was enacted. Why? Because our existing laws were unable to tackle sexual offenses against children. There was no adequate protection for children. How do we prevent them from being sexually assaulted? Protect them. And large number of cases were also not reaching the courts because of the stigma attached. How can we go to the police that there is a sexual offense perpetrated against a child? That is why we needed a separate law, which is separate from IPC or BNS. That's why a separate law called POCSO was enacted in 2012. Few facts. United Nations Convention on the Rights of the Child. India has ratified this convention in 1992. This convention has an obligation on it that you need to protect children from sexual exploitation and abuse. And you need to provide a gender neutral law. That is why in this law, the definition of the child is somebody who is less than the age of 18. And we have to protect these children. Now, whether this child is boy or a girl doesn't matter. We have to protect. So this is a gender neutral law. Let me tell you something else. Gender neutrality, is it from the victim's perspective or the accused perspective? So what are you trying to say? I'm saying, is this a gender neutral law which is meant to protect boy as well as girl below the age of 18 from sexual offenses? Yes. But who can be prosecuted under POCSO? Only a man? Or can a woman also be prosecuted for committing sexual offense against a boy less than the age of 18? On that, there is some problem. The matter is court. The court has to decide whether a woman can also be prosecuted for under POCSO if she commits sexual offense against a man, against a boy less than the age of 18. Or should we only prosecute a male who has resorted to sexual assault against the children? That's something that the court has to do. Yeah? So as of now, the clarity is that it is a victim-centric child law. Any person below the age of 18 is a child. And there are various offenses. Penetrative sexual assault, similar to rape, there is penetration. But aggravated penetrative sexual assault, if the rape is committed by somebody who has the authority, for example, a child is raped in the school or in the police station or by a relative, it is an aggravated sexual assault. And for that, there is death sentence. Penetrative sexual assault. And then showing pornography to the children is also under the ambit of POCSO. If you're stalking a child, committing harassment of the child, sexual harassment, it is also under the remit of POCSO. Provisions of POCSO are mandatory reporting, which means if a teacher inside a school gets a complaint that a child less than the age of 18 has been assaulted, you can't keep quiet and hush it up. You have to mandatorily report it to the police. If you don't report it, you are punishable. And then we have to take the statements of the victim, the child. We have to take statements of this child not in a police station, but at the child's residence or any place of his choice. A trained psychologist has to be part of this examination. Special courts have to be set up. In camera trials will be organized. That means where the outsiders will not be present. And you don't have to go for aggressive cross examination. What happened to you? Why did it happen? Can you show me how did it happen? Did you volunteer for it? Did you invite it? So this aggressive cross examination of the victim, of the child, is not allowed under this law. That is why this is a law meant to protect children, keeping children's interests are in mind. But there is a criticism. Criticism is that it criminalizes consensual adult adolescent relationship. And this is where in UK there is a Romeo Juliet clause. What does that mean? The girl is, let's say, less than age 18. Let's say the girl is 16. And then there is a man who is 66 years of age. And they are in a consensual relationship with each other. Is this allowed? No. Why? Because a girl less than the age of 18 cannot give consent. So what the 66-old man has done, he has committed rape. Look at the age difference. But what if this man is a boy and the age is 19 or 20 and the girl is, let's say, 17? And it is normal for a girl of the age of 17 to 19 to indulge in relationship with a 2-year extra age person. But this is a consensual relationship. But even if it's a consensual relationship, the boy is targeted for rape and prosecuted for rape. That is why in UK and in many other countries where children are protected from sexual offenses, there is this Romeo Juliet clause. which means if the age difference between the boy and the girl is within 5 years, then POCSO will not be attractive. Then this boy is not a criminal because they have indulged in adolescent sexual. Because the criticism against this law is that it has been weaponized by families. Whenever a girl is in a relationship with a boy and the boy belongs to a different caste or different religion, now the family of the girl files a rape charge against this. And there is an overburdening system. As of December 2024, there are more than 2 lakh cases which are pending in special courts of POCSO. But we have January 2026 update. As of December, we have crossed a milestone. All the cases under POCSO which were filed last year, 80,320 cases were registered, but we solved 87,000 cases, which means 109% disposal rate because these cases were pending for many years. Overall conviction rate is low. Pendency is also high. But it's only last year what we have done is that we have solved more cases than were filed in that particular year. So because of this milestone also 20, because of this milestone also, this question becomes important, this topic becomes important for you. That is why there is a question on your screen. Which of the following is a unique feature of the POCSO Act in contrast to general criminal laws in India? Let me know what is the right answer. It provides for capital punishment in all cases of sexual offenses against children. Not all cases. For example, it will not award capital punishment if you are showing child a pornographic video, but it will be death sentence if it is aggravated sexual penetrative assault. It allows police officers to decide whether a case qualifies for investigation or not. Police has to investigate. It requires the consent of the victim before registering an FIR. No, you have to register the FIR and start the investigation. It mandates child friendly procedures during investigation as well as the trial. During investigation, there can be, you have to seek the details, you have to call the witness, you can't produce this individual or this victim inside the police station. You have to go to her home, go to his home, record the testimony, or at a place which is directed by the child, where the child is comfortable. Psychologists are present, and no aggressive cross examination. This was topic number 17. Now we have topic number 18, Maternity Benefit Act. Who is this applicable to? Women employed in factories, mines, shops, commercial establishments, and other establishments. But these establishments should have employed 10 or more people. And to get the benefit, a woman must have worked for at least 80 days in the last 12 months, immediately preceding the expected date of delivery. So it's not that you will join an organization now and 1 month later opt for the maternity leave, because that will be burden on the employer. You must have stayed in that organization for minimum 80 days. You must have worked in that organization. Why is this topic in the news? Because in Umma Devi versus Government of Tamil Nadu 2025, in Tamil Nadu, they had the rules that we will provide maternity relief or paid maternity leave only for 2 children. But if there is an employee who has 2 surviving children, now for the third child or fourth child, we will not provide any maternity relief. Supreme Court said, no, you can't do that. You have to look at the significance of the Maternity Benefit Act of 1961, which was amended in 2017. Long story short, is a woman granted paid maternity leave for the third child as well, for the fourth child as well? Or is it restricted only to 2 surviving children? A woman will be paid 26 weeks of paid maternity leave for up to two children. But if you have more than two children, then 12 weeks paid maternity leave will be. That means maternity leave will not be denied to you, whether you have a third child or a fourth child. The only thing is, time period will vary. 26 weeks for up to two children and 12 weeks for more than two surviving children. This is not true that under Maternity Benefit Act of 1961, which was amended in 2017, you will get paid maternity leave for only up to two children. No, you can get it for more than two surviving children. The only thing is, for the third surviving child, the paid maternity leave will be only for 12 weeks and not 26 weeks. Clear? This was the list of current affairs topics that we had to discuss today, which appeared in various newspapers between January to June 2025. We'll meet again tomorrow, 7 o'clock in the evening, and we will discuss current affairs, polity current affairs of the period July till December 2020. If the session has helped you, benefited you, do not forget to press the like button. The PDF of the session will be available on our website. The link will be provided in my Telegram. I'll see you tomorrow. Till then, have a great time. All the best. Just don't panic. This is the exam that you will conquer. More than knowledge, during those 2 hours when you're attempting prelims, it's about how you control your nerves, how you keep calm. And if you can manage that, you can conquer the prelim. And for that matter, any exam in this world. Thank you for watching. Bye bye.